Hey everybody, good morning. I'm JD Houvener and welcome to the Bold Today Show. You've made it. I'm a patent attorney and owner here at Bold Patents Law Firm. And I'm here every Friday, 9 a.m. Pacific and noon on the East Coast. So we're here with a live audience. I know it can be kind of daunting. I always offer this disclaimer for those inventors and entrepreneurs out there maybe listening. Please do not share your invention. This is a public forum. If you want to talk confidentially about your invention, book a consultation, right? Visit our website at boldip.com. We're available. Our non-attorney advisors will listen to your case and make sure you're qualified to work with us. Hoping to get a nice live audience here today. I've got an exciting guest, longtime client, and in a lot of ways a mentor of mine, Barry Henthorn of ReelTime. We'll bring him on in just a little bit. He's one of our only publicly traded companies, so really proud to have him on and his company represented by our firm. I want to just let you know that I'll give you a couple of links here on our website. We're still giving away a copy for free of the book I wrote just a few years ago, Bold Ideas, the Inventor's Guide to Patents. There's a link right there to our site, and to get a copy of that PDF. This book is for all those out there that are just starting. Okay, this is the quick 1 or 2 hour, if anybody's hopping on an airplane still, it's an airplane flight kind of a book. Gives you all the basics: patents, trademarks, copyrights, what's the difference, how to get started, what's a provisional, what's a non-provisional. We lay it all out there. So we'll bring on our guest here in just a little bit, and hopefully get some people on and we get some good interactivity. The last half of the session here, I'll be going over our avvo.com questions, answering questions from a community, anonymous questions, I should say. I've got 3 teed up, 2 trademark related and 1 patent litigation subject matter. So, and for all those that are asking questions live, I will prioritize those. But we don't have any live questions. I'll just move on to those avvo questions. So without further ado, I will bring up Barry Henthorn of ReelTime VR. Barry, good morning. How are you?
Hey, I'm right here. Good to see you. Good to see you.
Excellent. Well, I'm so happy to have you on. This is fun, and it's a great day. It's a kind of a time of tumultuous year, unbelievable year. But we're going to celebrate innovation. That's the way we're going to solve these problems, is by continuing to move forward, to do new things, to solve the problems today. And one thing that I've been having fun with is bringing inventors on like you, clients, and I want to open up and just say congratulations on your recently awarded patent. It's been granted on the Spherical, a simultaneous spherical panorama image and video capturing system. So congrats to you.
That was quite the long name that ended up. I will say very, very glad to be here, but even more so the reason that we're here is almost unbelievable. Even to me, I've had a number of inventions throughout my career, and I've created quite a few different technologies and led a lot of development teams. And the fact that that you guys were able to do what you were able to do, I'm not even quite sure how it got done, but thank you.
You bet, man. And we were talking, just before the show we went live, and Barry, you're saying, one of the things that surprised you is that we were able to stick with it. And this is not not for the faint of heart, the patent process, right? And getting and acquiring and sticking with it. And so I want to thank you for sticking with us along the way too. I was looking at the patent, which will flash up here in just a little bit. We've been at this since 2016. And a lot of that is due to the USPTO's delay. And I'm going to show that the USPTO does give a little bit back in terms of your patent rights. So share with us a little bit about kind of your experience, how you first came up with this invention, what this invention is a little bit, and then we can flash the images up.
So I was down in Vegas and walking along the strip like most people do, and it was hard to walk on this one particular section because it was in front of the Eiffel Tower, and everyone was trying to stand up and take pictures and get on the ground and get the best angle and climb up somewhere so you could get that great selfie, that great shot, and it was just frustrating to see that they were having so much difficulty doing that. And then it wasn't until 3 in the morning, I woke up and it just hit me that if you basically had the ability to take all of the different angles at once, then you could then choose whatever the perfect angle you wanted was later. And then I thought, well, if you could take all the angles at once, you probably could do it 30 times in a second. And there you've got, full virtual reality video from all angles. And I know that some of the cell phone companies who had, some panoramic apps and so forth where you could take different pictures around, and that works fine if you're on the top of a mountain. But if you're standing down on the corner in Vegas where cars are going by and people are going by, you can't do that because everything's changing. When you can take it simultaneously, then then all those problems go away. And as we got to thinking about it, we realized that we could develop this from the simplest of formats where you could clip it onto your cell phone and anybody could take 360 virtual reality pictures or video and just instantly share it like they do with anything else now. Or we could take that to the next or the ultimate level, which is what we're involved in here, which is the highest end of virtual reality production that we're capable of, or that anybody's capable of. We keep pushing that envelope, and that we could utilize those same technologies at the highest level as well. So you get the consumer aspect of it, which will suffice for sending things out on Instagram and other social media, and you have the ability to migrate that all the way into where you're creating some of the the highest end productions that are possible.
Right on. And what I love about this too is that a lot of times these VR type innovations, present day we're working on with our inventors, they're software, they're methods, but they're quite complicated and hard to get your mind around. This is in essence not. This is a hardware, right? This is a device, an apparatus. It's so clean. I want to share this with everybody. Okay, so I'm going to share a screen here, show you on Google Patents, which is up live. Is it visible to you, Barry?
I can see it. Looks good.
All right. And so
it always looks good when I see it.
Fresh off the presses. This is patented September 1st. This is 17 days ago to Mr. Barry Henthorne out of Tacoma. And this is what the front page of a patent looks like for those that may not know. I'll just point out a few things here. Okay. We did mention at the onset of the show, yes, it was patented up here in the upper right, September 1st. But he has been at this for a while. We've been fighting hard for Barry, and what you've got a cool name for it, the Panorama scope, is that right?
That's essentially what we.
Okay, right. But look, so you can see that it was filed on July 19th, 2017. This is a non-provisional. Actually claims priority further back to July 2016. So you're going to trump any inventor that comes up with something like this after that date. So a lot of priority. And I want to make sure we give kudos to our team. I'm just the owner. I don't do a lot of the hard work, but Chris Melee, specifically, a patent attorney on our team, did a great job in actually working with the examiner, doing the interviews, working with Barry, crafting the claims, and is actually still working on developing your portfolio on this invention. So the child patent was filed just before this issued, looking to broaden the scope even further.
He really talked me, I guess, he talked me off the cliff at one particular time, because as you go down this path, for those who haven't been through it, as JD said, it's not an easy one. It's not something that just happens overnight. And when we got back from the examiner, basically saying in a nutshell, everything you're saying is not going to be good, and they just basically denied everything. And I was like,
right.
Well, why are we doing this? Why are we doing this? And Chris was like, oh, they just do that. They just do that. We'll just resubmit. We'll fix this. We'll fix that. And I'm like, okay, yeah, here
he's
we go.
Cool. He's cool as a cucumber, and I tell you, he's our best. He's our best at working with inventors, working with examiners, and just finding a way forward. So yeah, I'm happy you had that good experience. I do want to show off the invention here too.
Yeah, somewhat shocked, quite frankly, that he was able to do what he was able to do. As I said, this isn't my first rodeo by any stretch of the imagination. And we probably would have abandoned it and given up on it had it not been for the tenacity and the persistence and, quite frankly, the confidence in your team. Which turns out at the end of the day, I can see why you had the confidence, but at the time, I was,
Let's take. So look at this. So this is a patent drawing for one. So the end product will likely not look like this, but it's structured in this way so we can demonstrate the positioning, the parameters of a parent. This is a multi-directional mirror, and it's going to be able to gather light from the top here, right?
Mm-hmm.
And it's going to enter in through here, bounce off a mirror, and allow light to pass through what will eventually be a lens of a device that's put onto a camera, some type of device. And we were talking before the show, it actually may be the case that some companies are out there using this technology, maybe unknowingly, potentially infringing on this patent.
That's the thing that Chris really pointed out, and he, I don't want to say he slipped it in there, but the way that he was able to to word things and everything, pretty much puts anybody that utilizes a camera with one lens and or one mirror or more, on notice, because he was able to get something that was that broad, which as I said, I wouldn't have expected that.
Yeah.
I wouldn't even have been able to see that angle, coming at it, and it was just brilliant.
Yeah, and it's it requires mirrors, and this is one of the key things I remember in our first discussion is this may require a little editing, but the whole idea is that it will not require traditional stitching, right, of multiple images. It is one shot, and it took me a while to actually get that around my head. One shot that captures everywhere.
Right.
I mean, it takes a little bit out, folks that are used to shooting and pointing at a rectangle. No, this is one shot for a photo of the entire space around you. And then taking it to the next level, like you said, putting together multiple shots to make video. Pretty astounding. So you haven't yet. I mean, tell me what's your plan? For moving this product forward. Is it going to be part of your company, or more of a position for technology transfer?
I think it's a dual path. I think it's really a dual path. I mean, we have the ability to do both, as I said, both the consumer aspect of it. We're certainly in licensing conversations and so forth, and looking into production of that as a consumer entry level $20, $40 product that can clip onto any cell phone, etc. Right on up to working with some of our partners in the virtual reality world that are developing cutting edge elements of things to be able to interact with what they're doing, so we can utilize the technology to do that as well. And one of the other things that came out of this wasn't just the invention itself, but as we began to understand it and understand the intellectual property, it spawned all kinds of other ideas, which is the primary reason we were able to do our other major technology that we're able to do, where we can shoot in full virtual reality and then take that same content and convert it into flat technology, flat like you're used to seeing on regular television,
right,
which none of the other virtual reality processes are able to do that.
And help me out there. So, I mean, going from taking 360 photos or video, how does that translate to getting to VR? I mean, help me kind of make that leap.
Well, there's a couple of ways that you can typically capture VR. One is to have multiple cameras, 5, 10, 18, however number, depending on what level you're trying to do. And there's been some consumer plays like GoPro, etc., that came out. Now you're talking about a consumer play that's still going to cost you $5,000, because you have to buy all the cameras, and then once you're done with that, you have to put it into a stitching software, and you have to do a bunch of stitching, and it's a time-consuming, very, very expensive thing to do. That's fine, but in the world of virtual reality right now, it's not monetized in the same way that traditional television is. You have your Oculus, you have all of these tremendous platforms that are coming out, and they're growing, exponentially. It's incredible, but you still don't have the ability to monetize that type of content the way you do something that could be shown on traditional television, on cable, on social media, etc. You're limited to those platforms that are able to take that kind of content. So when you're able to film with that content, you're stuck. So you have a higher cost of production with a much smaller audience of which you can go out and monetize it from. What we're able to do now is to take that same production that we're able to do and not only have it go to all of the portals that we have with Oculus and our other partners, but with to go out into regular traditional television. So that's how we were able to get our content that was shot in VR on Amazon Prime, which is the #1 virtual reality show or travel show in the world in front of you, became an Amazon Prime special. So you can see the whole series there right on Amazon Prime now. It's the same stuff that we shot utilizing these technologies, but we're able to monetize it in both ways now.
That's awesome. And something that's this simple, like you said, a $20 type of a gadget.
Well,
I mean,
exactly the device used for those productions.
Right. But I mean, the idea is that the everyday consumer could get close. I mean, with something like this, that's incredible.
if you
And
go
you're
back,
talking, yeah.
you go back to the early days of the camera phone. I mean, why do you want a phone on your camera? And
Yeah.
and it was terrible. And to go back to the days of digital photography, no one would do that for anything that was going to go in a magazine. Now you pretty much wouldn't shoot with film unless you were just trying to go for a special historical look or something.
Right. No actual benefit to the performance. Right.
No.
Wow. So what is next? We got 3 months of the year left, Q4 in this wild, turbulent year. What's next for you? What's next for your company?
Well, as far as what we're doing with the patent and with our development of the product that comes around that,
Yeah.
we'll continue down those paths. There's strong interest in a number of identified major players, and without naming them, I'll just call them major players, who we believe have multiple infringements upon this, which in its simplest form wouldn't have been an option. But in the way that you guys were able to get the breadth of the patent written and the foresight that you had looking forward to this, it opens up the capability for some infringement that we think will be very successful with.
Yeah. And I mean, for some of those inventors that may be just getting started or not even invented yet, this is perhaps a new concept for you, that you work hard, the arduous labor of getting the patent acquired. I think the initial notion is that, hey, I've got to go build a product and go start selling it and create a market for it. And I get to sort of tell them that, look, there are a lot of ways to monetize a patent. You don't have to be the one that goes and builds it, develops the market and demand and sells it. You can work with and actually make business partners of infringers, right? Mm-hmm. If there really is that way, and a path to monetization, whether it be licensing or enforcement. So long as you've developed and acquired a rock solid patent asset, you don't need to, you're not stuck with that one mode. So I'm encouraged to hear that you're interested in looking into that, and we'll be happy to work with you, of course, on getting that started. I want to make sure we get to the rest of our feature here today. We're going to go to avvo.com next. But Barry, I want to thank you for being on today and for sharing your invention with us.
Absolutely. I just want to say one more thing here. Your book that you wrote, the Bold Ideas book. I've read it a couple of times, and it's that's the one, of course.
Yeah.
And, thank you for the other copy of it, because the other copy that I have is all tattered and used up and marked up. Not because I've read it, but because when people come to me, which is a very common thing, and go, hey, I've got this idea, blah, 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 blah. And they don't really know much more than that. I've given it out and said, well, here, read this. And then you'll know more than most people know, who've taken some time to try to do research on the internet, et cetera. It's pretty much right there. It's easy to understand. And I completely recommend anybody that wants to learn more about that path to read it. As I said, I certainly have, on more than one occasion.
Thank you, Barry. That's awesome. Okay, we're going to put you backstage. Barry, you're going to stay on. So if anybody has questions that maybe watching this after the fact or catching up on live, we'll put him backstage and he can answer questions before we're done here in about 12 minutes. I see we have 4 viewers on, so thank you for that. And for anyone that's watching that hasn't yet given us a like, just give us a like. That's how we're going to create more space. Share this video with anyone you think might be, on that edge of whether I should file a patent or not, and they're just maybe innovating or tinkering. This is a fun way to get them involved and get in front of a patent attorney to ask some high-level legal questions to get them started. So without further ado, I'll jump in to avvo.com. We've got 2 trademark questions. These ones are about applications. This first one comes out of Fort Lauderdale, Florida. Looks like it's related to clothing. So the question is a clothing trademark specimen with the logo on the front of the shirt, in the middle, and on a hang tag, does it qualify as a specimen? I'd like to trademark my brand, but want to make sure I have all the correct requirements. Okay, so a little bit of background here. As part of trademark, registering a trademark, the USPTO, the trademark office, will require that you show that you're actually in business. They do not want to and will not give a registration for a brand, like Bold IP, if you're not actually engaging in commerce. They want to make sure that consumers are actually going to be able to witness and see your mark in practice. You have to show them that you're selling. For a lot of folks that are online, a screen grab, a screenshot of your storefront will usually do the trick. For those that are selling goods and are in a store, a physical store, they do want to see the actual product. And it's not like a lot of people think. It's not like the logo on the shirt. It's actually what's on the tag. is what matters, right? The actual manufacturer. If you're the one that is the source of those goods, that's what's actually being sold is the shirt, not the artwork on the front of the shirt. So it's a common misconception, hey, I got to get my logo on the shirt and sell it. No. It's actually all about what's on the tag of the shirt. That's what counts. So that's what they're going to need. It could be one or two different articles. A final thought there will be you'll need to also include any other types of goods that you're trying to claim. As part of the trademark application, you'll want to have a listing of the different classes. So there's 1,000 different classes out there. One, of course, is apparel. And then within that, you'll specify shirts, pants, hats, whatever else you want to try to sell. If there's another area of business, for example, let's say tailoring, that'll be a separate classification. So you have to provide evidence that you're actually providing tailoring services, perhaps in the form of a receipt or some way that you've been in business. So hope that helps answer your question there. Let's jump back to our second trademark question. This is out of Murrieta, California. How much does it cost to file an LOP for a newly filed but not yet granted trademark? Someone filed a trademark for the words, quote, dog mom. They filed that on August 13th, just this year, for 9 classifications, one of which conflicts with the product that they sell. Their first use date is January 1st. My first use is July 2 years ago. So they seem to have priority using the term dog mom as a tag on all the pet themed jewelry. And doing a quick Etsy search, there were over 300,000 quote dog mom listings that would get shut down if this common phrase would get trademarked. So, is there someone that can help me file an LOP? And how much would that cost? So, an LOP, I actually have never heard of that acronym. I'm assuming it's sort of like a cease and desist or a letter opposing the mark. This particular person asking the question is obviously knowledgeable of the products they're selling and is very aware of this competitor that's now registered, or at least filed for a mark. And it sounds like since it's in its matriculation phase, part of that last final part, even if the trademark examiner says, yep, dog mom looks good, it now goes for a period of opposition. So opposition, I think that's what this question asker is asking about. During the opposition period, anyone that's got a conflict or can say, no, I've used this mark before, you claim to have, you can oppose it. And so that was the time. It's about a 30 to 60 day window to oppose the mark before it gets registered. And of course, the fees will be all over the place in terms of what sort of complexity there is, and if there's any type of issue with the specimen and demonstrating that you were in business before the registering. So a lot at play there, and I don't want to quote the cost right now because we want to have a consultation first. A lot of different attorneys could help you with this. We obviously focus on patents and help our inventors protect their marks. So if we're not the best fit for you, we will find out who will be in the California area. So thanks for your question. That was very good. Any live questions we have? Okay, good deal. I did see a note here from Milton Watson. You've got so nimbusspot.com, utility patent seeking license agreement. Okay, I'm not sure there's a question there. Milton, if you're still on, could you help me understand what the question is, or I'm not quite sure what that means. It sounds like there was a separate utility patent granted, perhaps related to spherical panoramas or type of video capturing, image capturing technology. So let us know what the question is or how, what that means. Let's see, I'll go to our last question here from alvo.com. This is a patent infringement question. And it's coming to the Los Angeles, California area. The question is the design process of a new product, they're in the design process of a new product. How do we make sure our device doesn't infringe on an existing patent? I'm the design engineering process with a new one. I found one patent that is similar to our product. How do I ensure our product doesn't infringe on this patent? We have no plans to patent our device, but of course we prefer not to get sued. Okay, interesting. So this is a great point. I think the person asking the question may be a little confused. So by virtue of acquiring patent rights, okay, you are not infringing, right? So you may be granted rights for a scope of claim. And even if you think that based on that scope, if you were to build that product, that is when you would actually have infringement. When you start making and selling a product, that's when you have to have the problem. So the actual legal structure of acquiring patent rights, I would say the vast majority, probably 40 to 50% of all patents that are issued, these days are improvements, right? They're just one or two steps, one iteration, one non-obvious, twist to the current state of the art. And so they're adding, a feature, an element onto an existing product, and that product in many cases is protected by one or several patents. And so it's the case that hey, they've got a patent, that's awesome, good job, but you're probably not going to be able to sell that without being infringing on those underlying patent rights. So to know really the degree and the scope of how many patents you may be infringing on, a lot of our clients ask us to perform what's called a freedom to operate opinion, where we'll do a landscape opinion focusing on your exact product and saying what the degree of risk is that you're infringing, and also to help you in terms of changing or tweaking your design so that you're avoiding infringement on your product. For those that are really certain that there's only just one patent out there and they're willing to take the risk that there are others, we can do, of course, a much more quicker assessment of one particular patent like you've got and help you understand, hey, what exactly are you selling? Does it read on all of the elements of that invention, of that patent? And in most cases, patents are more specific than you think they are. A lot of people will look at the first page of a patent, look at the figure and think, oh my gosh, our product is so close to what they've described here. But you actually scroll down to the claim language and it's very specific, right? They've only got, the bumper, little flange. That's all they actually own is the flange on the front bumper. But on the front page of their patent, they've got the whole car, right? Because they want to highlight and try to, seem like they've got more rights than they really do. So give us a call, have a look. We'll look at the patent claims and hopefully calm you down and make sure that if there is an issue, we can get you back feeling better about going to market. So here's our website in case you guys haven't seen that yet. And for those that have obviously that are brand new, maybe joining us a little bit late, I want to make sure you know that we're still giving away a copy of Bold Ideas: The Inventor's Guide to Patents. Free. It's online download. Hop on our website. Put the link up above here. And if you're ready to get started on this process, I've got trained non-attorney advisors that are ready to get on the phone right now and listen to your invention and make sure that we're a good fit. Know that we're a law firm. We are not a patent promotion marketing company. We're not going to sell you down the river. I mean, this is legal advice. This is what I believe all inventors deserve, is to get sound legal advice on whether they have an eligible invention and whether the invention is patentable, what steps to take next. So I'll be happy to work with any of you. And I enjoy having this audience on. I see we've got some good viewers on. And if you're watching this after the fact, again, like I said, give us a like, share this video with those you may have in your community on Facebook, on Google, YouTube, or on Twitch. It's been my pleasure talking with you. And I will bring Barry back on to say goodbye. Barry, thanks for hanging out backstage. It's been good to see you. Thanks again for joining, and we'll have you on some other time in the future.
Oh, absolutely. And again, thank you for your team. And you just mentioned how virtually most all patents are, when you dive down on them, very, very specific. So, I mean, that's just hats off again to your team for being able to get such a broad patent actually passed through. And then, the whole baby patent process at the end there, extending, our ability and our claims, as things develop into the future. Again, thank you so much for being the professionals that you are.
You're welcome. Take care, Barry, and take care, everybody. Have a good day. Go